in all likelihood, we won't have any formal decisions to make anyway.
Right.
All right, so let's begin. I'll just turn it over to you, Sarah.
Okay, so not a lot happened this week with the storm. We were supposed to have 4 hearings on our bills on Wednesday, but we only had one. So 2106 was up to repeal those statutes about once in jeopardy.
Okay.
And no issues there and got a due pass. That's on the floor today. The rural attorney bill got a due pass and that's on the floor today. A couple
and that's
other
not been amended at all, right? Still
Nope.
8.
No amendments. No amendments have been offered, so. And then previously 1058, the small claims, and then the summary disposition and summary dismissal bills have been, they were heard in committee, got due passes, and those are on the floor today as well. Not a whole lot else happened this week. Next week, we have a bunch of, it's kind of a busy hearing week next week, so there'll probably be more to update next Friday. But the municipal court study is up on Monday. 2296, that got amended in the Senate to basically eliminate the Chevron deference.
Yeah.
So that's where it stands right now, is that it would be eliminating that deference and a study regarding administrative hearings.
You know, I took a look at that. I think Public Service Commissioner Randy Chrisman flagged this for me. I think it was this one.
Yeah, because initially it had nothing to do with us. Because it was only talking about ALJs. But then it got amended, I believe, at the hearing. And they amended it to put in that amendment to do away with judicial deference to administrative agencies.
Okay, that's interesting. I don't know if I see Judge Hurley's joined us, if either of you has looked at this new language.
I have not.
I was kind of unaware of it.
Let me just read it real quick. I just pulled it up on screen just so that we're all on the same page here. It says, it's a new section to chapter 2832 entitled Judicial Deference. It says, notwithstanding any other provision of law in interpreting or applying a statute, regulation, or rule, a judge may not defer to a governmental entity's interpretation of the statute, regulation, or rule. After applying all customary rules of interpretation, the court shall resolve any remaining ambiguity against increased agency authority. It's an interesting interpretive rule. I mean, we have a bunch of those in chapter 102, I think. I'm not sure why they wouldn't put this there, but.
It's a good question.
Yeah.
I wonder if any other states have gone this route or not.
I'm not sure I'm aware of any doing it by statute, perhaps. I think the Ohio Supreme Court recently addressed Chevron and reversed some of their prior cases giving agencies deference. But we historically, I don't believe our cases suggest that we give much deference anyway. If it's a legal interpretation, it's de novo. And unless it's a very technical regulation, like to some extent oil and gas type regs or Medicaid type regs, I think we might have cases relating to those. But beyond that, and even in those areas, I don't think we tend to defer unless there's ambiguity. But in any case, I think it's useful to keep an eye on that one because that'll change your handling of agency appeals.
Yes, indeed.
Okay, well, interesting. Thanks for pointing that one out. I hadn't realized that one had changed so significantly.
Yes. Yep, it originally, when I originally looked through the bills, I remember that one because I read through it because it said relating to judicial deference. And I looked, I'm like, well, this has nothing to do with district judges. But then it suddenly did. So
And so you said the prior version of this was the one that dealt with ALJs in there?
right.
Okay, good.
Yep. And then they amended it to include the district judges. So then it got added to my list.
Okay, well, good to know.
Oh, that hearing is on Tuesday at 11. So I'll let you
Okay.
know next week what happened.
Yeah, especially if any agencies file any testimony in opposition, or if there's any substantive
Oh.
discussion, I think I'd be interested in hearing that.
Okay. Our budget is up on Tuesday afternoon at 2:30.
So Sally and the chief, anybody else? Don Wolf, I suppose.
Yeah, those are usually the three.
Has anybody heard who the Judges Association is having to, I know it's not really the purview of this committee, but I'm just out of curiosity, who's coming down for that?
I do
I
not.
haven't.
Okay,
Yeah, I think we're always interested in state bar or other folks that are going to testify on our bills, but absolutely, we sort of have our arm's length relationship with the outside groups.
no doubt.
Let's see. The bill kind of cleaning up the juvenile stuff is up on Tuesday. And then our 3 other bills that were supposed to be heard on Wednesday will be heard on this coming Wednesday morning. So the temporary court of appeals, the fitness to proceed, and the definition of meeting.
Okay, so you'll be submitting similar testimony to what you did on the other side?
Yep.
Okay.
So 9, 9:30, and 10. The guardianship task force bill is up on Wednesday morning also. They took out the funding portions of that and instead included it in all the various appropriations bills, but kept the task force to provide recommendations on accountability rules, and kept the FTE so far for a Supreme Court attorney. So
Okay.
see what happens with that. And then, so the Supreme Court building bill failed, but a study resolution was submitted. And so that one is up on Wednesday morning to study the feasibility and desirability of moving us to the Liberty Memorial Building or a different building.
Does that one have any funding attached to it?
I don't believe so.
Okay. I don't know if they
It's-
ever do that for studies, you know?
Not that I can really think of. I suppose only if the study itself would need funding for some reason.
Yeah, like if they wanted to consult with an architect or somebody to
Right.
get a more detailed estimate of cost.
Mhm.
Anyway, that may well come up. Is Representative Clemene still leading the charge on that?
Yes.
Okay.
Well, that, it is interesting, because I was thinking that very same question, Justice Puffy, and it occurs to me that if there isn't, and not that we need to take a position on it, but this is just general discussion, if there isn't funding associated with it, I think we'll be subject to the same criticisms that there were before, that we don't have a funding plan in place or whatever else. But well, with a study resolution, that'll be for the legislature to own, I guess.
Yeah, I don't know if they appropriate like a small pot of money to fund any costs related to the various study committees that they select, or how they handle any of those kinds of things.
Right.
Okay, well, I would imagine somebody, perhaps the chief, will have a chat with Representative Clemene about responding to the concerns that the House side raised on that, and hopefully, if there are some questions that can be answered fruitfully in the interim, should they choose to study this, it'd be nice to be able to come back with an answer for what you do with the people in the Liberty Memorial Building, or alternatively, what a new building looks like and where it goes.
Right.
So, okay, well, we'll keep an eye on that. Thanks, Sarah.
And then the bail schedule bill is up Wednesday afternoon.
Yeah, well, remind me who's on which side of that one, or who's testified.
Me. I provided some neutral testimony because they wanted the background of what the court has kind of done up till this point on that issue.
Did John Byers come in for the state's attorneys on that one?
Don't think so, but I can
Okay.
look quick.
Is he generally representing the State's Attorneys Association, or only a couple of bills?
That I'm not sure. So far, he's the one I've seen
Okay.
doing it, but I don't know entirely. Let's see. Oh, I see so Travis Spank put in testimony in favor. Jeff Clayton put neutral testimony. Is he? American Bail Coalition. They do not believe the Supreme Court should be tasked with setting the uniform statewide bail schedule.
Okay.
They didn't come and testify, so I didn't even notice that before. And then the Fargo court put in testimony in favor. But all it is their bail schedule.
Were we sort of divided amongst the district judges about what we thought about that?
Likely.
Yeah, I mean, there were district court judges on those committees where we talked about it. So.
Yeah, I would say it was, there was certainly differing opinions on it, yes.
Okay, well, probably just same kind of a testimony you had before then on that one.
Mm-hmm. So, and that's the one that I did have Representative Schneider put in that amendment to narrow the scope of when that applies. So,
Okay.
So it was very clear that it's only pre-appearance.
Okay.
And then let's see. I don't know if there's any others really that we need to talk about right now. The gun study is up for hearing on Thursday afternoon, but that they just rolled most of the gun bills into a study to determine all of the sensitive areas that guns shouldn't be allowed, and all the places guns aren't allowed but should be.
Okay. Any questions, Judge Eldweek, on any of the things we've talked about or haven't yet talked about?
I don't believe so. Thank you.
Judge Hurley, anything from you?
I do not. Can you hear me?
Yeah.
Okay. I was having problems with my other microphone, so.
I would say
really good
this
today.
is, yeah, this is the best that we've been able to hear you, I think.
Yeah, I've got a ticket to fix up my microphone because I have my laptop up. I have, whatever.
Oh, okay.
I have an issue.
We've had some pretty good luck with the external USB Logitech cameras. They have a built-in microphone too. Anyway, help desk should be able to help you out.
Yep, absolutely.
I did chat with Katie Paulsgraf about those library bills.
Yeah.
And they could potentially include the law library. And so either we'd want to provide some testimony on that or just change, like right now, you can only go by appointment. But we'd have to kind of lock it down. So it's really only judicial employees and attorneys who can use the law library, like to actually go there and check out books and whatnot.
Yeah, did anybody else look at the text of that? I just looked at that the other day because it's been in the news again.
Yeah, they're not great.
Well, I think there should be an exception for like a research library that
They specifically removed that exception.
they removed that exception.
They sure did. I don't know why either, because if their aim is minors, yeah, it used to say under exceptions to criminal liability, and I'm looking at 2360 at the moment because that one is, it applies to way more things. So they removed or public library for limited access for educational research purposes carried on at such an institution by adults only. So I don't, and I haven't been able to really find an explanation for that.
Do you think there are problems with how they define the obscenity that the bill is targeting?
Oh, I think there are many, many problems with these bills. I think they go far outside of obscenity.
Okay.
Yeah, I question the constitutionality of these bills.
Well, I don't have any comment on that. But
I do think they
standard.
go, I think they go outside of what is typically considered obscenity under current laws and current like US Supreme Court case law.
Well, that's what I was going to suggest. I thought it had the standard exception for serious literary, artistic, political, or scientific value, which would seem to cover
Yes.
most anything in a research library to begin with. But I'm
But
not sure
the way
what...
that they define explicit sexual material is, I think that is the issue, and it seems to apply anywhere a minor might be able to see it. So I think
Okay.
it's very broad in its application potentially. For instance, 2360 applies Class B misdemeanor for displaying at newsstands or any other business establishment frequented by minors, which I'm guessing could be a bookstore or a public library, or they might be invited as part of the general public. Any photograph, book, paperback book, pamphlet, magazine, the exposed cover or available content of which either contains explicit sexual material that is harmful to minors or exploits, is devoted to, or contains depictions or written descriptions of nude or partially denuded human figures posed or presented in a manner to exploit sex, lust, or perversion. And it previously, so the standard is usually when taken as a whole, but this they removed principally made up of, and instead just have contains depictions or written descriptions. So it's very broad.
Okay.
And 1205 doesn't actually limit it to minors in the actual text.
Do you think this is just a query, I guess, and I'm looking at which the Senate one,
2360.
2360, it says, and I'm with the eye towards the law library, shall not apply to the possession or distribution of material in the course of law enforcement, judicial, legislative activities. So I'm wondering, is the law library, is it too broad to say the law library is a judicial activity under that exception in section 4?
I don't know that we could apply that to anyone outside of like the judiciary who's
I see.
using it.
It's a person and not institution exception is kind of what you're saying.
Yeah, I think if the law library were only available to, judicial employees and attorneys, then I think we would be outside of the scope of these bills. Because we would not be open to the general public.
Right.
And
Yeah,
so
I don't know, I think
minors
we'd
aren't.
have an argument that our self-help center is a judicial activity, but it's probably debatable.
Yeah.
What this is a little difficult because we've got a Supreme Court justice here, but do we tell them? How do we go about doing this? Saying, I think that this is kind of a mistake to not include exceptions, and I don't know. We can't take a position, can we?
No, and we've never forecast there might be constitutional problems with something or
Exactly, because we can't give advisory opinion. Yes.
Right.
Whew.
So, our concerns would have to be limited to its application to the law library.
Well, I would think the law school too.
Yeah. I don't know if we would really be the ones to take a position on that. But I am kind of surprised that the universities didn't, and they might have put in some testimony, but.
Well, could we just ask for a straight up explicit exemption from the law library as an amendment?
Well, let me think that through just for a second, because I don't want Katie or the court implicitly to say, we have obscene materials in our library and we want to be exempt.
Well,
No,
right.
no,
Fair
no,
enough. Fair enough.
I really doubt we have anything that would qualify as obscene, but I don't know everything in our collection.
I don't think we would have anything that qualifies as obscene under the definition of obscene material, but these bills are something else. They are defining explicit sexual material, and it's extremely broad. And Katie said that there are things that, especially under 2360, which also includes written descriptions, that could potentially fall under that. And she would have to, if it were a public library, she would have to go through the entire collection to determine that and get rid of books that would fit under either of these definitions and create this policy and provide a report to legislative management.
I don't know if we should talk any more about this, to be honest with you, now that I'm thinking about this, just in case this comes before Justice Tufte.
Well,
It's more the issue with the law library is
Right.
what I think is the only issue we can.
yeah, and that's why, and I understand and respect your opinion, Judge Shirley, but I think this is within the proper scope of this particular committee, and I think that's why I would suggest just to talk about the law library, because that is something that we do have an interest in, and that we can have a discussion about, and so that was why I just proposed that.
I understand that. I'm just wondering if
I'm not concerned yet about the scope of our conversation. I'm trying to be as diplomatic as I can here. Librarians have a very expansive view of First Amendment protections, probably even more so than the court's very expansive view of such First Amendment protections. As I'm reading 2360, it's not just explicit sexual material, but it also has that is harmful to minors. And then the second part of it, written descriptions, etc., to exploit sex, lust, or perversion. Now, if we have things that are exploit sex, lust, or perversion, or if we have things that are harmful to minors, we should probably get rid of those rather than worry about getting an exemption. And so it's whether that's vague or not clear enough to administer that we should.
What happens if someone at the Harvard Law School writes a law review article about it and quotes the material in the book, and then it's in by default? in the law library as a result of being in a law review article.
Well, the
That's
hard
what I'm-
part is whether that's harmful to minors or whether that's for purposes of lust or perversion.
One of the issues is that, so there is a
That's the thing.
definition. There's a definition of harmful to minors. However, that definition does not apply to this particular section. It specifically applies to 2 other sections, but not this one.
So it'd be a plain meaning approach to whatever's harmful
Right.
to minors.
Mhm. It's just, it's a little awkward to navigate.
Well,
Yeah.
yeah, my only thought is just to protect the integrity of our law library, and specifically, okay, just that process of even going through the materials, that in and of itself, I think is onerous on the court. So for just that reason, I think seeking an exception or exemption might be worthwhile. I just propose that. I'm not sold on it, or anything else like that, but I just propose that.
I agree with that, Judge Eldweek.
Well, we have a quorum if somebody wants to make a motion to that effect. I'm not sure exactly. I've heard anything specific quite yet.
Well, do we have some time on this, Sarah?
Yeah, there's no hearings scheduled yet.
What
So,
I would like to bring it up next time around, maybe if we have Judge Matz and Judge Clark involved too, and I haven't really given this a lot of thought. It wasn't even on my radar today. So I just propose we talk about it next week, and if we have more participation, great, and if not, that's okay too. But it gives me time anyways to think more about it. But I do think it is worthwhile as I sit here now to maybe look at doing an exemption. So
yeah, and look at the wording of the 2 bills on their own, because I mean, they are different from each other. And I don't know if come conference committee time, if they're going to make it one bill or what will happen with that. But
Can you say the number of the House bill again?
yes, it is 1205.
Okay,
So,
because at this point, I'm not worried about 2360. I'll just be out front on that. But
Okay.
if Katie has something specific, a little bit more specific she wanted the
Mhm.
committee to consider, I'd be happy to
okay.
look at that more closely.
yeah,
So-
if you could talk to her about it, and if
Mhm.
she wants us to focus on something, Sarah, I'd sure be grateful.
Okay.
And I haven't studied the House bill yet, and I just had the Senate bill on my plate. So I'll look closer at that before our next meeting as well.
And then those fundamental parental rights bills, the juvenile court directors have had some concerns about those having an effect on what they do and the court's ability to handle child welfare cases appropriately. So if you want to take a look at those before next Friday also, as far as that particular issue. If
Would you make sure to, in your materials for the ahead of the next meeting, to remind the other 2 that aren't on the call about those?
Yes. Yep. So. And those are, let's see, 2260 is the Senate bill. I've misplaced my House bill. $13.62 is the House bill.
Thank you.
That's all I have.
Okay, well, thank you for the thorough update and a good discussion from everyone here. I don't have anything else myself. Anything, I know we went around once already. Anything else for the good of the order?
Nope.
No, I don't want to jinx us by bringing anything else up, and I don't have anything either, so we're good.
All right, well, we're right at 30 minutes. That's a good time to close here, and then we'll watch for that reminder next week on the couple of homework items for all 5 members of the committee to discuss.
Thank
We are
you.
adjourned.
Thank you.